Dhruvi?
Yes, ma'am.
Dhruvi, you can start.
Yes, ma'am. Ma'am, am I both visible and audible?
Yes.
Thank you so much. Napoleon Hill once said, "The way of success is the way of continuous pursuit of knowledge." Good afternoon to one and all present here. I, Dhruvi Sharma, a second year law student, is your host for today's session. Legal drafting is the most important instrument of legal communication. The skill to draft well is the skill to think and communicate well. It is the most important skill required by an advocate. And hence, Trinity Institute of Professional Studies is organizing a lecture series on value-added courses on legal drafting from 13th September to 31st September 2021. Today, it gives me immense pleasure to welcome our keynote speaker for this event, Dr. Aman Hingorani. We welcome you, sir. I extend my warm greetings to Dr. R.K. Tandon, Chairman of Trinity Institute of Professional Studies. Dr. R.K. Tandon always endeavors to provide quality education to the students. I now request our distinguished Chairman, Dr. R.K. Tandon, to kindly address the gathering.
Thank you, Dhruvi. It gives me immense pleasure to address this august gathering of legal professionals, academicians, and students on the occasion of the inauguration of value-added course on legal drafting. I am pleased to welcome the eminent speaker of the day, Dr. Aman Hingorani, a practicing lawyer, mediator, and arbitrator at Supreme Court of India. Trinity Institute of Professional Studies is firmly committed to provide ample opportunities to the students to enrich their personalities to their full potential. In pursuit of this vision, Law Department of Trinity organizes this value-added course to equip students with knowledge and skills with respect to legal drafting. The main idea behind this value-added course is to improve the employability skills of the students. Therefore, to enhance the potential of the students, several eminent speakers from diverse fields of legal fraternity have been invited to impart knowledge regarding legal drafting. The focus of our institute is on discovering and developing the knowledge base of students, which is not restricted to theoretical aspects only, but include the practical learning as well. Legal drafting is an art and it can be acquired through knowledge of law, procedure, settled judicial principles, besides proficiency in English language. A perfect drafting obviously leads to good results in terms of money, time, energies, and expectations of not only the learned members of the bench, but also the bar, as well as the parties of litigations. With these words, I commend the Law Department of Trinity Institute for introducing this value-added course. I wish all the participants good luck for their future endeavors and looking forward to them becoming elite law professionals. Over to Dhruvi, please.
Thank you so much, sir, for your kind words. I now welcome Dr. Barkha Behel, Director of Trinity Institute of Professional Studies. We welcome you, ma'am. I now call upon Dr. Barka Behel to kindly begin the session with some words of wisdom.
Thank you, Dhruvi. Good afternoon, one and all present here. It's great pleasure to welcome all the dignitaries on the panel. Dr. Aman Hingorani, resource person of the day, Dr. R.K. Tandon sir, and Professor Shashi Bala, Principal Law Department. I am glad to welcome all for today's session, a value-added session on legal drafting. I also extend my hearty welcome to all the students who are participating in this value-added courses and have registered themselves for pursuing this course till 31st. We at Trinity Institute of Professional Studies believe in providing holistic grooming environment to the students for their personal and professional growth. Number of series of activities we have been organizing throughout the year to groom the students, be it related to curricular, co-curricular or extracurricular activities. Under these series, this is one among them, the value-added course on legal drafting, which has been initiated by Law Department to hone the skills of the students on the same. I believe that students would take maximum benefit of the course and will learn through various practical examples and case studies. I will conclude with the phrase, our brain is a hardware, our thoughts are software. It's time for update. Be aware, otherwise people treat you like malware. This means that to meet the challenges ahead, it is necessary, it is compulsory to remain dynamic and to change ourselves with the changing needs of the society. With this only in mind, these sessions have been organized. I would like to extend my gratitude to Chairman Sir for always inspiring and motivating all of us to hold such sessions. Thanks to Dr. Aman Hingorani for agreeing to be resource person for today's session. Thanks to Dr. Shashi Bala ma'am and all law department faculty members for organizing this session. And I welcome my wishes to all the students for gaining maximum out of this value-added courses. Thank you once again. Thank you.
Thank you so much, ma'am, for your kind words. I also welcome Dr. Shashi Bala, Principal, Law Department, present faculty members, and all the students. I now request Dr. Shashi Bala to say a few words.
Thank you, Dhruvi. I'm audible.
Yes, ma'am, you are.
Respected Chairman, sir, Director, ma'am, Dr. Aman Hingorani, the eminent speaker of the day, and dear participants. Good afternoon to one and all. First of all, I welcome the eminent speaker of the day, Dr. Aman Hingorani, who is a very renowned personality in the field of law and having experience in diverse areas as a lawyer, a mediator, arbitrator, as well as experience of teaching to law students, judicial officers, lawyers, and law teachers in India and abroad. Thank you, sir, for accepting our invitation for delivering a lecture on the civil writ petitions. It is our proud privilege and honor to introduce the value-added course on the legal drafting, focusing on different types of the legal drafting, which will not only add knowledge, but also provide a practical understanding of drafting mechanism. You will learn how to draft a legal document. It is our proud privilege and honor to introduce the value-added course on the legal drafting, focusing on different areas of legal drafting, which will not only add knowledge, but also provide a practical understanding of drafting mechanism. You will learn how to draft a legal document, whether it is a civil or criminal petitions. Legal drafting is an important skill for lawyers It involves learning how to draft various kinds of petitions to be filed in court, drafting contracts for clients, preparation of legal opinions or legal memos. Drafting skills are crucial to perform well in your internship, as you receive various assignments during your internship which require you to go through and proofread dense documents. If you know how to draft the important legal documents, your ability to comprehend dense information and perform the task allocated to you will be substantially enhanced, and you will stand out from your peers. So we have decided to launch this course keeping in mind that drafting skills and practice will enable you to build confidence and feel equipped to understand and handle a variety of tasks assigned to you during internship and also as a junior lawyer. With these words, I end here and I welcome once again and hand over to Ms. Dhruvi Sharma. Dhruvi, over to you.
Thank you so much, ma'am. Since Brain Herbert once said the capacity to learn is a gift, the ability to learn is a skill, and the willingness to learn is a choice. So I request the students to float their queries in the chat box, if any, during the session. Dr. Hingorani is a practicing lawyer, having been called to the bar in 1992. He is an advocate on record at the Supreme Court of India and has argued cases on diverse fields of law before the Supreme Court, including its constitutional benches, various high courts, and tribunals in the country. He has also been elected as a member of Executive Committee, Supreme Court Advocate on Record Association, Supreme Court of India. Sir has been impaneled by the Supreme Court Legal Services Committee to act as the Legal Aid Counsel. He devotes a substantial part of his professional time for pro bono work. Dr. Hingorani acted as a mediator in Supreme Court Mediation Center and the Delhi High Court Mediation and Conciliation Center. He has also been appointed as an arbitrator by the Delhi High Court and the PhD Chamber of Commerce and Industry, New Delhi. Sir has been engaged in teaching law and professional skill development at law school since 1998 as a faculty. He has authored a book, Unveiling the Kashmir Knot, a saga bestseller, which pieces together a practical and a novel solution to the Kashmir issue that has escaped consideration so far. Sir has another 71 publications, both national and international. Now I request Dr. Aman Hingorani to enlighten us with his valuable words.
Mr. Tandon, Ms. Behel, Dr. Bala, faculties, students, friends. Well, thank you very much for giving me an opportunity to address you and share my views on legal drafting. This is one area which has not really been covered much in our the way we teach law in law schools. It is basically what we are normally given is textbooks or formats on pleadings, conveyancing, and we are told, well, these are standard formats. You can perhaps rely on them to make a particular draft. And of course, these textbooks do have advantage, and these formats do have advantage because, particularly for law students, they help in identifying the legal requirements. They help in identifying the gaps in your drafts. So you're prevented from committing an error by omission. These templates do give a suitable structure to organize material. They offer apt phrases tested over time. So if you use a word like latches, which means delay, undue delay in connect for text or writ petitions. So you just use the word latches that convey something. We also save a lot of time, particularly if it's an electronic template. But for those of you who have done internships, who have gone to the courts, and who have been asked to do some drafting, you probably would have figured out by now that there's also a disadvantage of simply relying on set formats from books or from the internet, particularly if it's an electronic template. We all would have at times included irrelevant matters which we did not feel the need to remove. We could have let some odd details being unchanged because we forgot to do editing. Then there may be something missing in the original format. And if we're simply doing a cut and paste job, we omit those vital matters. The templates itself may be based on outdated law. They may be poorly drafted in the first place. It may be inappropriate. So you would need to draft all over again yourself. And of course, if you're stuck with a template, you will never ever get the confidence to make a legal draft. So as has already been indicated by the chairman, by Ms. Bahl, by Dr. Bala, the focus of this value-added courses is for you to acquire the skills of doing a legal draft. In other words, legal drafting has to be seen as a performance skill. It's all very well to be able to get substantive knowledge, to get procedural knowledge. But what about having the performance skills of being able to draft a particular document? So what I intend doing is sharing with you the one particular formula of doing legal drafting. There are many ways you can learn how to do legal drafting. But what I will share with you is perhaps the simplest way by which you could draft a document containing a legal element. And since the topic of discussion today is civil writs, I would put it in context of civil writs. But since you will be doing this course and you'll be probably be hearing other faculties or resource persons on different kinds of drafts, perhaps you could adapt the formula or the 6-step process I'm about to share with you in those drafts. Now let us assume that you all are lawyers. Your client has come to you with the problem, with the grievance. Let us assume you've used your excellent communication skills to gather full information. So you have oral facts being given to you, you have documents being given to you. Let us assume that this is a case, take any hypothetical case, maybe there's a building which has been constructed without, which has unauthorized constructions, and the local corporation is coming and trying to demolish it, but the corporation has not given any notice, so there's a violation of principles of natural justice. So you have decided you must file a writ petition, a civil writ petition, to get a stay of that demolition drive, saying, well, we were not given a chance to explain our side of the story. There was no notice given to us. There's been a violation of the principle of natural justice. So a writ should be issued to the corporation not to demolish this particular building without following procedure, due process of law, and so on and so forth. So that is assuming that is just the crux of the matter. You have a bundle of documents, bundle of facts. What do you do? So the step one of any exercise in advocacy is to do a case analysis. You must be able to analyze a case, which, and the result of that analysis would be a case theory. We always work backwards. Your case theory is your final argument to the court. Your argument cannot be beyond your pleadings or the documents on record. And so whatever you want to say must be reflected in your documents, must be reflected in your pleadings. And so even before you get down to drafting, you must have your final arguments in mind. So it's your case theory which actually dictates the presentation of a draft. A good draft is one which seamlessly follows one paragraph into other. This happened, and this happened, and this happened. And so my client is entitled to this relief. So we'll talk about how to get to that stage. But before you get to that stage, you must have in your mind a clear strategy, a case theory, not necessarily what the client has told you. Client is a layperson. You, once you become lawyers, are supposed to be able to convert what the client has told you into legal language, into rights and liabilities. And so for that, you need to be able to analyze the case. Again, there are many ways by which you can analyze a case. The simplest way is to take out 4 sheets of paper. First sheet of paper, you can write on the top legal elements. So regardless of the facts of your case, or divorced from the facts of your case, what are the legal ingredients of this case? So for instance, out here, if you're talking about civil writs, you know a civil writ can be filed either in the High Court or the Supreme Court. So you should have mastered Article 226 for the High Court, Article 32 for the Supreme Court. You would know the distinctions between when you can go to the High Court, when you can go to the Supreme Court. Supreme Court, you can file a writ petition claiming relief against the state as defined in Article 12, which involves the violation of a fundamental rights. So the right to move the Supreme Court to protect fundamental rights itself is a guaranteed fundamental right, and the Supreme Court can issue a writ of, depending on the case, the writ of habeas corpus, mandamus, prohibition, quo warranto, certiorari. Would anybody like to tell us what these writs are? Anyone? What's the writ of habeas corpus?
So
No
it
one?
means to have a body. It means habeas corpus means to have a body.
Yeah, so you can produce the body. What about writ of mandamus? To command. The writ of mandamus is basically to tell a statutory body, do your statutory duty. If this is your duty, you're supposed to perform and do it. So that's the writ of mandamus. What is quo warranto? Yeah, Lakshay has raised his hand. Whoever.
Lakshay, you can unmute yourself.
What is
So, quo warranto
Yes,
franchise is held.
I beg your pardon?
Yes, sir.
Yes. So what is quo warranto?
So that's
It is by which, it's come in the chat also, by which authority. So basically, if you want to ask somebody under what authority are you holding this public office? So simplistically put, that is what quo warranto is. Certiorari is when you're trying to, when you go to superior court to challenge the decision of inferior tribunal for, say, want of jurisdiction and so on and so forth. So quashing the orders of the inferior tribunal. Prohibition is like injunction. You prohibit a person from doing something if they're acting without authority. If you see the language of Article 32 is wider. It's not only the 5 traditional writs, but also any order, direction, or writ in the nature of these writs. So that could include compensation, for instance. Or if you widen up, if you bring in PIL, having taking over the administration of a particular institution, like the Supreme Court did for Ranchi Mental Asylum, or constituting fact-finding bodies, so or having investigative bodies. So there's a huge amount of power which the courts have. It's not confined only to 5 traditional writs which are there in the English law. So you have to be familiar with the substantive law as to when you can go to the Supreme Court. The right to move the Supreme Court is a guaranteed fundamental right. According to the full bench of the Supreme Court, in Ramesh Thapar's case, 1950, the Supreme Court has said Supreme Court is constituted as a protector of fundamental rights, and the existence of an alternative remedy does not entitle the court to throw out a petition. And the same proposition was laid down in 1959 by another constitution bench in Kochini's case, which said, even where the disputed questions of fact, but there's a violation or allegation of violation of a fundamental right, Supreme Court cannot throw out the petition. Supreme Court has to even record evidence on affidavit if that's what's required. Of course, over the years, in 1988, we had two Supreme Court judgments of two judges. One was Brahmbhatt's case, one was P.N. Kumar's case, where they laid down the proposition that if the High Court can give you the relief, don't bypass the High Court and come to the Supreme Court directly, go to the High Court. So where the relief can be given under Article 2 to 6, go to the High Court. Don't come to us in Supreme Court. And that, in my view, is where the Supreme Court, in a way, abdicated its constitutional duty. It's the job of the Supreme Court to protect fundamental rights. Even Supreme Court cannot whittle down or try to give away its powers, which has been imposed on it by the Constitution. It's not a discretion of the Supreme Court. It's a constitutional obligation of the Supreme Court, and there's a fundamental right to move the Supreme Court directly without having going to this High Court. But that's become a practice over the years. So even if you're drafting, you must know which court you want to get into eventually, whether it's High Court or directly to the Supreme Court. Existence of alternative remedies anyway not a bar for writ jurisdiction. It's a question of practice and what the courts have laid down, that we have the power, but once we see an adequate alternative remedy, let the party first exhaust that remedy before coming to us. As far as High Court is concerned, Article 2 to 6 is wider than Article 32. You can move the High Court not only for the violation of fundamental right, but for any legal purpose, not only against a body which is state under Article 12, but against any public authority or person to protect that legal right of a person. So BCCI, for instance, is not state under Article 12. So you can't file Article 32 petition against the BCCI, but you can file a 226 petition before the High Court against the BCCI. So these are so when we're talking about the first sheet of paper, where you write legal elements, you would need to master the law on writ jurisdiction. Article 32, Article 2 to 6, in a given case, if it's a PIL, because PIL is also a writ jurisdiction, then you would need to see the rules of PIL, which are there framed by the Supreme Court and High Court. What are the legal requirements of those rules? You have to keep in mind the principles underlying, the legal principles underlying writ jurisdiction. There should not be an alternative remedy, though it's not an absolute bar, as I pointed out. There should be no latches, there is no delay in moving the court. You can't sleep over your rights and then suddenly come to court after 5 years, and so on and so forth. So your first sheet of paper, I'm not getting into a discourse on writ jurisdiction. I assume you know the substantive law. But the point I'm trying to make is, once you're going to make a case theory, and in the example I gave of illegal construction being demolished, violation of principles of natural justice would attract writ jurisdiction. So that would be a legal ingredient. That's one of the grounds on which the writ court can intervene. So you would, on sheet 1, put legal elements. On sheet 2, you would say, put what you think are your good facts. Whether this person had a building plan, is the legal construction within the compoundable limit, the fact there was no notice, so there's a violation of natural justice. So sheet 2 would be your good facts. Sheet 3 would be your bad facts, facts which are against you. At the end of the day, it is illegal activity. It is unauthorized construction. So at best, you're going to defer or delay the demolition. And the fourth sheet would be facts to nullify a bad fact, to explain away a bad fact. So it is illegal construction, but it can be compounded. It is illegal construction, but if they give me notice, I would have removed it myself within so much time while preserving whatever malba there is or whatever my valuables there is. So sheet 1, legal elements. Sheet 2, good facts. Sheet 3, bad facts. Sheet 4, facts to nullify bad facts. It is only, and then you would correlate your good facts with your legal elements. If you want to show, if your legal ingredient is there should be adherence to principles of natural justice, your good fact, no notice was given. So you correlate this. It is only after this that you can say you mastered the law and the facts of a particular case. This all you need to do before getting to drafting. Because in any given case, there can be more than one case theory, and the skill of a lawyer is to choose a correct case theory. Now, and of course, the parameters of a good case theory is it must be consistent with the law, it must take into account whatever the other side can say against you. It must be reasonable, it must be logical, it must accord to common sense, it must be ethical. You can't suppress documents, you can't suppress facts. So whatever case theory you have made after studying the law, after sifting the facts in this way, good facts, bad facts, facts to nullify bad facts, not necessarily the categorization you have learned in Evidence Act or in your other subjects of oral facts, documented facts, relevant facts, irrelevant facts, admissible facts, inadmissible facts. Those are different categories. You have to keep all that in mind while you're taking out good facts and bad facts. Once you've mastered this, it is only then you can pick up a paper and pen or open your laptop and you can think about drafting. Now, before you, what do you have? You have 4 sheets of paper. You are about to draft a writ petition. Because of your case analysis, you have a clarity of what you're about to draft, what's the purpose of that draft. You know what you want to say. You know what you don't want to say, or how you're going to explain away a bad fact. But everything is spread out on 4 sheets. What do you do now? So we come to step 2, which is putting all the material at one place to determine the essential content of the draft. Some of this material, and you have to organize them in paras, some of these materials could be mandated by the rules like PIL rules or the case law, whatever is required by the case law. Some of these could be directed or mandated by practice directions. So if you see a writ petition in the High Court, you'll say in the matter of violation of Article 14, 1921, and in the matter of a writ of so-and-so, and in the matter of, so you have a recital in the cost title itself. These are practice directions. So you need to put that at one place in this list you're making at step 2. Other paras would be mandated with the needs of your client, your own logic, what is to be pleaded in a case, and so on and so forth. But the point is, and even the requirements that there's no efficacious remedy, there's no latches, this court has the jurisdiction. Whatever you want to say, or to put everything at one place so that you don't forget about it or you don't leave out something. Having done that, you would now create a skeleton plan. The material is the flesh, but you need a structure. So you'll make a skeleton. You would organize those paras which you put at step 2. You will number those paras. You will try to see in what order those paras will come, because facts will be stated chronologically. So first para could perhaps introduce your case theory. This matter is about this. And then the relevant facts are, you give that chronologically, numbering each para. Try to give each para one name. So if you're looking at talking about violation principle of natural justice, so that idea or that content, you'll give the name violation of principles of natural justice. All the facts you want to say will come in that particular para. If there are multiple facts, split them into sub-paras. Number the sub-paras. So the idea is to, by doing that, you want to keep the focus on the content of the para. You'll keep to the point. You won't mix up in one para what belongs to another para. But so far what we're doing is we're just putting everything, you're organizing material. We're just putting it in a particular structure in bullet points or incomplete phrases. Having done this particular, so the step one was case theory, case analysis. Step two was putting everything in one sheet. Step three was to create the skeleton plan to give it a structure. Now we come to step four. Step four is to basically go cross-check with the list you created as step two that you got, and the four lists you had when you did, which you created in step one. Just ensure that everything is being incorporated. You're cross-checking that every necessary item of content has been slotted into your skeleton at the appropriate point. Because every para should hang together, it should be in the right sequence. A para should not contain something which should not really be there, but which belongs to some other para. So you're having a relook at your material you've organized by cross-checking your skeleton plan against the list you've created. It is only after this that you start drafting. As step 5, you draft one para at a time. So if you see what you've done right now, you're not worried about your draft being against the law because you've done your case analysis. You're not worried about your draft not being complete because you put everything in one place. You're not worried about your draft not having a structure because you've already drafted, you've already put things in a skeleton plan with one para following the other, chronologically stating the facts. Now you're focusing on the language. You have to draft one para at a time, concentrate only on the language. There's plenty of space. Just keep in mind when you're drafting a para that the name you're given to that para should only be about that. Every word is important. Every phrase must be apt. Language should be clear, precise, unambiguous, complete, non-repetitive. Each of these words are important. They connote something different. Because you also have to keep in mind that a good draft should not only be consistent with the law or be complete or structured or have appropriate language, it has to be readable. The judge has to read it and understand it. And so you must know exactly what you want to say. You have to be clear, precise, complete, unambiguous, non-repetitive about whatever you're saying. If it has to be readable, you can't use legal jargons in a draft. You can't use slangs in a draft. Use plain, simple English. Short sentences, not more than 8-10 words in a sentence, not a sentence going into 4 lines. Nobody can read that. So maintain simplicity while framing a sentence. Ensure there are no errors of spelling, punctuation, grammar, tense. It's basically a creation. The draft is your baby, you're creating it. So whatever you need to do by trial and error, chopping and changing till you feel you have a good draft. Rearrange the words, alter the punctuation, divide sentences, join sentences, add brackets, remove brackets. Whatever editing you need to do, whatever changes you want to do, you can keep doing it again and again. Just because you have reached this stage, it does not mean that you have finished drafting. Step 6 is to look back over your draft. Once you reach the last para, start from the beginning again. One tip is stand before a mirror, take your draft in your hand, read it out to yourself. If the reading is disjointed, check the language or the sequence of the paras. If something is there, which should not be there. The flow is not coming. Because like I pointed out, one para must flow into the other para. The more you read your draft, more you will want to make changes. If you have the luxury of time, sleep over it. Draft something today, forget about it, revisit it tomorrow. You'll want to make changes. You won't want to put something differently. You'll notice something different which you would otherwise have missed out. After completing the draft, you will come to the perhaps most crucial part of the writ petition you're drafting, which is the prayer clause. Because at the end of the day, the court is going to see the prayer clause before giving relief. What prayer you have asked. You might have got a perfect draft. The body of the draft may be perfect. But if your prayer is defective, the court can't give you that relief. So you have to take attention, pay special attention to the prayer. When we talk about the prayer clause must be self-contained. It must, the court, and I'll give you an example. The example we talked about, you're seeking the quashing of a demolition notice, and you're also seeking restraining the corporation from coming and carrying on the demolition. For example, if these are the two prayers, you would say, in the circumstances, it's most respectfully prayed that this honorable court be pleased to, 1, number your prayers, issue a writ direction, an appropriate writ direction or order quashing the demolition notice dated so-and-so, the full details in respect of property number so-and-so, full details of the property. Your second one would be, prayer B would be, issue a writ of prohibition restraining the respondent corporation from demolishing the construction on, don't say the aforesaid property, again repeat the details of the full property. The prayer must be self-contained. If there are multiple prayers, each prayer must be numbered separately, and each sub-prayer or each clause of the prayer should itself be self-contained. So you would then, and if there are multiple prayers, you can do 1, 2, 3, 4, whatever, and the last prayer would be the residual prayer, pass any other order as may be deemed fit and proper. Remember, in pleadings, we do not cite law. Pleadings are on the facts. You can refer to a legal proposition that this particular action constitutes, that could be a ground that this constitutes a violation of principles of natural justice. But you're not supposed to be giving case law on that. That's not the purpose of pleadings. Similarly, in a counter affidavit, the response filed by the respondent, they can take legal defenses of estoppel, laches, and so on and so forth. But so you can take legal defenses, but again, the respondent won't be citing case law. It's not a moot court memorial where you have case law. In pleadings, there should be no law pleaded. You're pleading facts, and people win and lose case on facts, how you stitch the facts together, not on legal precedent, because every case stands on its own feet, on the facts and circumstances of that case. So if you see what we are talking about out here is the skill of legal drafting is a performance skill of stitching the facts in such a way that the court feels that your client is entitled to the relief which you're seeking. And that is something like, I'm keeping a track of the time. I do want to make this more interactive and to open the flow. But the focus which I've seen in law schools is to, at best, circulate formats. And even the question papers simply say this is a fact situation, and then you're supposed to mug up a particular format and then just state the facts given in the question paper. That is not legal drafting, because the legal drafting is not the standard paras. The legal drafting is presenting the relevant facts in such a manner, giving them a particular slant, so that it captures your case theory. And once you're, and because you're, and that case theory, like I said, has to be done keeping in mind your final argument, keeping in mind that what you have, and once that is reflected in your pleadings, remember, your pleadings are the foundation of your case. Once you have pleaded something in the trial court, here we're talking for the writ petition, but generally speaking, once you have pleaded something in a trial court or in a writ court, your client is stuck with that right up to the Supreme Court. You can't change it. That's the foundation of your case. So drafting should be, is one of the most difficult skills actually. Drafting and cross-examination of witness are two skills which a majority of lawyers are not able to master even after being in practice for decades. But if you follow the simple formulas or strategies to be able to draft, you'll internalize the process and you'll be able to make a draft without taking the help of a format or a template, electronic template. You can refer to it to get a broad structure. So even if you come to a template, the template will say you will have the mandatory paras, but the template will leave it blank. The relevant facts are and there's a blank. How do you fill that draft up? What are you going to put out there? That is where your skill comes in for doing legal drafting. So to conclude on this particular area, for a writ petition or for that matter for any legal draft, the parameters of a good legal draft is what I've already mentioned. It should be consistent with the law. It should be structured. It should be complete. It should contain appropriate language. And most importantly, the draft must be readable. There's no point having a draft of 200 pages with multiple documents, facts all over the place, and the court not understanding why have you put something there. And you'll be surprised to see once we actually come into practice, and we see that in Supreme Court, drafts from certain states, the writ petitions would go on to 120 pages, 130 pages. Whereas a good draft, if you can't make your point in 5-10 pages, you can never make a point. Particularly when we have the entire body of law that a writ court is not going to go into a disputed question of fact. So you're not really pleading facts, you're not really pleading evidence. You're revolving around the criteria of seeking the 5 traditional writs or writ directions or orders in the nature of those 5 traditional writs. So you don't really need 120 pages, 150 pages for that. So the crisper you are, the simpler you are, the better the draft will be. You need to demystify your draft. You have to make the case as simple as possible. The more complicated you make it, the more legal jargon you put in it, the more high sounding you put into it, the more chances are that you will, the court is not going to touch it, or at least not going to give you the relief upfront. They'll want to understand why you're putting all those things in. So with that, since it's almost 4 o'clock, I think I'll stop here, but, and I'd rather spend the rest of the time taking questions, answering doubts. If anybody has any question, I hope most of you know what's the difference between a writ and an appeal and a suit, because you must have all that, you must master the substantive law and procedural law before even you think of getting into legal drafting of a particular proceeding in a court of law. Fine. So the floor is open.
Thank you so much, sir, for such an enriching session. There are certain queries that the children have put. I request you to please address the same. One of the questions that we've got is, can a writ petition, once admitted, be dismissed on the grounds that an alternate remedy is available?
Well, that is the law which is laid down by the courts, that the existence of alternative efficacious remedy, it does not take away the power of a writ court to give relief, but the practice is that the court will not give relief. The court will first tell the party, go and exhaust your alternative efficacious remedy and then come back to us. Now, that proposition, as far as High Court is concerned, in my view, is perfectly justified, because if you have an alternative remedy of appeal, etc., there's no reason not to go there, and instead of coming straight to the High Court for judicial review of a decision. But when it comes to the Supreme Court has taken a similar view for Article 32, but in my view, the Supreme Court is unjustified in taking that view, because Article 32 itself is a fundamental right. The right to move the Supreme Court is a fundamental right. Article 226 is not a fundamental right. So the High Court can exercise judicial discretion to say, first exhaust your alternative remedy. But the Supreme Court has no jurisdiction. It's the constitutional job. It's the constitutional obligation of the court. That's a function to protect fundamental right. The Supreme Court cannot say that first go exhaust other remedies when the Constitution guarantees a litigant that the Supreme Court will give him that relief directly. So that, in my view, the Supreme Court is wrong in having taken that approach. And as I pointed out, that approach was taken from sometime in mid-80s, when you had two judge decisions, which did not refer to larger bench, did not refer to Ramesh Thapar, did not refer to Kochani, larger bench decisions binding on them. But these two judges simply went ahead and said, there are good reasons why the High Court should not be bypassed. So if there's an alternative remedy before the High Court, don't come directly to the Supreme Court. Unfortunately, that's the law as it stands right now.
Thank you so much, sir. Sir, there is another question as well. Whether a writ petition seeking recall of directions issued in a SLP maintainable?
No, SLP is a case will be in the Supreme Court. So there has to be clarity about when you can file a SLP. So you would file a SLP from a determination, a finding of the High Court. So if the Supreme Court in its appellate jurisdiction has decided something, then a writ will not lie. If somebody is aggrieved with the directions passed by the Supreme Court in a SLP in excess of its appellate jurisdiction, then the remedy is to file a review under Article 137. And if still the person has a further grievance, then the person has a remedy of filing a curative petition. With Ashok Rupa Hura's case, this inherent jurisdiction was created by the Supreme Court, and the curative petition will be listed before 5 judges who would then examine that matter. So there's a remedy prescribed under the Constitution of review and by the Supreme Court of a curative petition, not a writ petition.
So there's another question that how should we draft a prayer?
Well, prayer basically is the relief what your client wants. So in the example I gave, well, don't demolish this place, this construction without following principles of natural justice or giving due notice. Until that is given, till the due process is followed, prohibition or so on and so forth. So you need to, when you're doing your client interviewing session, you need to understand what your client wants. And then you need to be able to draft the prayer, delivering that relief to the client. So the client will simply come and say, well, I want to protect my property from demolition, etc. You need to find out what's the appropriate provision in the Constitution, whether it will be 226, which is the appropriate writ which is there. How are you going to formulate that particular relief in the legal language? Fit it into what are the reliefs that can be given by a writ court. And then you will be drafting that particular prayer. But one is that that's a substantive part of the prayer. The second is, as I pointed out, the prayer should be very clear and unambiguous. The court must know what is sought. So if there are multiple prayers, number the prayers separately, not one big para. If you see many of the textbooks and you see a prayer clause, the prayer clause will be several prayers all jumbled up in one para, going into 10, 15 lines. Now that's a bad draft. The prayer should be, in the circumstances, is most strictly prayed that this honorable court be pleased to pass A, B, C, D. With prayer A, prayer B, prayer C, prayer D being self-contained. So that is the way you ought to be drafting the prayer clause.
So what are the relevant grounds that can be included in a writ petition?
Well, again, the grounds are limited in the sense that it's a question of errors of jurisdiction. See, writ jurisdiction, if you, I mean, like I stated, that you have to be clear when you can file a suit, when you can file a review, when you can file a revision, when you can file a writ. Now, writ petition will file for judicial review of the actions of the state or public authorities. So you would bring in issues of, say, where authorities acting without jurisdiction or there's an irregular exercise of jurisdiction on jurisdictional issues or failing to perform statutory duties. So you have to see the 5 traditional writs and you'll know the grounds on which you can take. If somebody is being detained without authority, you can file habeas corpus. If somebody is fraudulently filed some certificate and is holding a public office, you can seek quo warranto. Or if somebody is being disqualified from holding public office and is still holding public office, you can file quo warranto. If the authority is not doing their job, if the municipal corporation is not clearing the litter or the garbage, or there can be, there's so many statutes. If there's a the statutory body is not either complying with the statutory requirements or not acting in consonance with the statutory requirements, you can file a writ of mandamus. Prohibition is injunction if the action itself of the state is illegal and you want to restrain. The state is, in this case, like I pointed out, trying to demolish something without giving notice, then you can seek a restraint order that if your action is illegal, which is unconstitutional, then give injunction not to act illegally. If there is a certiorari would come in where inferior tribunal is active without jurisdiction, take a situation, it is a civil court which has passed a decision with respect to certain land which is under the revenue courts. Now, civil court would not have the jurisdiction if it falls within the revenue courts. They don't have the power. So you can file the writ of certiorari saying quash the decision of the civil courts. They've acted without jurisdiction. Or where there's malified action, arbitrary action, violation of principle of natural justice, bias, error apparent on the face of the record. So these are the kind of grounds on which you can file a writ petition. You can't file a writ petition where there are disputed questions of fact. If there's a dispute of title, go to the civil court, not to the writ court. You can't file a writ petition without exhausting all your remedies. You need to give representation to the authorities to do something what you want them to do. If they don't act within a reasonable period of time, then you can come and file a writ petition. You got to exhaust your alternative remedies, provided they're efficacious. If they're not effective, they're not efficacious, then of course you can say there is a remedy, but it is not an effective remedy. It's illusionary. That's why I'm coming straight to the writ court. So all this is part of your substantive law. Whenever you study with jurisdiction and the power of judicial review, you'll see the kind of grounds on which a writ can be filed.
Sir, there's another question. How to find out whether a particular case law is applicable in our case or not?
Well, first, you see, once your client has come and told you this is the facts of the case, and you're doing your case analysis of your legal element, or take a case if it is on I mean, for a minute, if we stop talking about writ petition, if we're talking about, say, matrimonial law, say, divorce matter, then you would, your client has said, I want divorce on cruelty, the cruelty. Then you would look up the entire law on the grant of divorce on cruelty. You would see the facts of your client, which they've given you. And then you will be able to see, once you have mastered the facts and you have a case theory in your mind, then you would know what kind of case law to look for. Without knowing what is going to be your strategy, there's no point hunting for case law. You need case law which will support you. And should you have a case law which is against you, then you must know either how to distinguish it or you change your case theory, which is the reason step one of the drafting, which I pointed out, is research and drafting case theory, which you can do only after you've done your case analysis. Unfortunately, what happens in most offices, particularly if you're interns and you're gone there, you'll have your senior will tell you, the client has come, I've told the client to give a list of dates or the statement of facts. Just type this in, convert I into the petitioner, the other side into respondent, and the petition is ready. That's a wrong way of doing drafting, because the client may have given some fact which is actually against the client. You need to apply your own mind to evaluate those facts, to sift those facts. Are they unreservedly in your favor? Can this fact be used against the client? It is only after that exercise that you can formulate a strategy. And it's only after formulating a strategy that you can go around seeing which is a case law which can help me persuade the court that this is the right view of the matter, or this is the view the court should take on this particular matter.
Thank you, sir. Sir, there is another question. Is there any difference between drafting of civil writ before the High Court and the Supreme Court?
Well, not really. The format is more or less similar. But if you have a civil writ for PIL, the rules are slightly different. Supreme Court PIL rules, the affidavits, you have to file certain kind of declarations. And in the High Court, Delhi High Court PIL rules, there are certain paras you have to put in the writ petition itself, which is not there in the Supreme Court. So you have to see the rules of the Supreme Court and High Court when it comes to PIL. But for non-PIL cases, the format is more or less the same.
Thank you, sir. So, is there any difference in drafting in different types of writs?
Different kind of writs. Well, there is, well, again, not really. You see that the stages or the skill of drafting remains the same, regardless of whether it's a writ or civil or criminal or even other pleadings for that matter. What changes is the content, for which you need to see the law. So for a civil writ petition, you'll have to plead no latches, etc. For a divorce petition, you have to plead, if it's on a case of cruelty, that there's no condonation of cruelty, there's no collusion between the parties. So those mandatory paras, you've got to take from the substantive law and the procedural law. That is there any other case filed by you? If so, what happened to that particular case? So you need to disclose that. So you have to keep your substantive and procedural law on that particular topic in mind to see what paras to put in the content of your petition. But the skill of drafting remains the same.
Thank you, sir. So, what are the relevant grounds that can be included in a writ petition?
I just mentioned that, relevant grounds.
Thank you so much, sir. Sir, also Saloni Singh wants to ask a question to you.
Yes.
Sir, I think she's having a bit of audio issue, so I'll speak a question.
Yeah.
How should we cite a case law so that it is in favor, so that it favors our case and makes it strong?
Well, actually, you see, let me answer that question this way, that we don't really cite case law in court unless we have to. It's only where the law is not clear or there's a divergence of judicial opinion on a particular point that we cite case law. which is the reason why I always have maintained that moot courts is a good way, a good example of how not to argue a case. Because what you do in a moot court, now that we've talked about a case theory, in a moot court, both sides will have the same case theory, they'll have the same set of facts, they're the same issues. Whereas in real life, the facts of both sides can never be the same, the issues can never be the same. And we win cases on facts, not on law. So you don't really need to cite law. It's not an academic exercise the way it is in moot courts where you have memorials where you need to say, in this case, this happened, or in this case, that happened. And you don't really feel satisfied till you have told the judge each and every case law you've taken out. In real life, we just have a couple of arguments which we want to make on facts. And the minute we get the relief, we sit down. We don't go beyond that. We don't say what we don't need to. If we don't need to argue, we don't argue. Now, having said that, if you do need to cite a case law, there's a particular way of going about doing it. You do not read in court, whether your oral arguments or even judgments for that matter. But that puts the judge to sleep, is a communication inhibitor. You lose the interest of the judge. If you do need to cite a case law, you will simply say, I seek to rely on this so-and-so's case, which is, just give the citation, which is an authority for the proposition. State the proposition in your own words. The court may be pleased to come to page so-and-so. Take the court to the particular judgment, wherever you want to take the court to. Wait till the court opens a relevant page. Identify which line it is, 5th line from the bottom, or 10th line from the top, whatever it is, and say the court has found this point. Read out the one line you want to read out. Close the book. Correlate that what you've read out, the proposition, with the facts of your case. So, if the examples are given, if I seek to draw I'm relying on the decision of the Honorable Supreme Court in the case of so-and-so for the proposition that it is not open for the respondent corporation to take coercive action against the petitioner in the absence of a show cause notice, because that amounts to a violation of the principle of natural justice. If I may take the court to the relevant line of the judgment, which is on page so-and-so, I'll wait till the court reaches there. I'll read out that particular line. Then I'll close the book and say, so in the facts of the present case, the failure of the respondents to issue show cause notice has resulted in the violation of principles of natural justice, warranting interference by this court to quash the demolition notice, the action of the, or to restrain the corporation from proceeding with the demolition, or so on and so forth. So the point is that you would contextualize the case law you're reading on the facts of your case, not in abstract, that this happened in this case and this happened in that case. The court is not interested. It doesn't need to know that for deciding this case. So that's the way you use case law once you have, also should you decide you really want to cite a case law.
Thank you so much, sir, for answering all our queries. Once a great man whispered, no duty is more important than that of returning thanks. I deem it a great honor to propose the vote of thanks to all those who have helped us in making this webinar such a resound success. I thank our distinguished speaker, Dr. Aman Hingorani, for making this session interesting and meaningful. Thank you so much, sir. I also propose a hearty vote of thanks to our chairman, Dr. R.K. Tandon, for his benign presence. I would be obliged to express my profound gratitude to our director, Dr. Barka Behel. I also thank our principal, Dr. Shashi Bala, for her moral support. I happily express a vote of thanks to our faculty members who guided us throughout in conducting this event. Finally, I would like to thank the audience. I now request everybody to please switch on their cameras for a group photo.
Ajay sir, is the photograph done? Thank you, everyone. Thank you. Thank you, Chairman sir. Thank you, Aman sir.
Thank you everyone. Thank you again.
Yes, sir.
Thank you, Dr. Aman. Thank you so much for coming. Thank you.
Sonakshi,